Hello, my name is Andrew Grosjean. I'm an advocate for unemployment hearings. I am licensed to practice law in California, but I do work and live here in Michigan. In Michigan, you do not have to be an attorney to represent people at unemployment hearings. I've been able to represent both employers and claimants for their unemployment hearings, although most of my work has been with claimants. People sometimes ask me what is my ratio of wins to losses, and when they ask me that, I explain this to them. Attorneys that are concerned about having that 100% win rate do that by only taking cases that they know 100% that they can win. I don't follow that line of reasoning because I believe that everyone deserves a chance to have their case presented in the best possible way. With that said, I do sometimes take cases that have less than 100% chance of winning, although I can't handle cases where there's no chance of winning. I do represent those cases because even if the particular judge in that case may tend to go a certain way, or this issue may be a difficult one, claimants do have a right to have their story told in the best possible way, and that's what I strive to do for them. If you were to feel comfortable with me handling your case, what I would do is I would set up a time to do a consultation with you. The consultation can be done either in person or over the phone. If you want to do it in person, my office is in Taylor, although sometimes I can do it at other locations as well. And if you want to do it by phone, that's fine as well, as long as we don't have a lot of paperwork that we have to deal with. At the consultation, we would go over all the details of what happened. I'd let you know what to expect from the hearing, what to do, what not to do, if there's anything about the judge that you need to know, and we'd get all the details organized. Different judges do like to see things presented in certain ways, and I can help you prepare for that by letting you know what certain judges will be looking for. And if we need to subpoena any witnesses, we can do that, as long as we do so at least 4 days in advance of the hearing. If there's a telephone hearing, which sometimes happens, we need to make sure that any documents that you want to be considered at the hearing are presented both to the judge and to the employer at least 4 days in advance of the hearing. Now, a lot of claimants believe that as long as they've submitted it to the unemployment agency, that's all that they need to do to have those documents admitted during the hearing. However, the rules say that those documents need to be resubmitted to the judge and also to the employer in a telephone hearing. And the reason for that is simple. Oftentimes what you've mailed to the unemployment agency in your unemployment correspondence is lost or doesn't show up in the file, and the other side may not have the file. So you have to submit those, and it's best to do it by fax probably, although you can mail if you have enough time to do so, or hand deliver. When you go to a hearing, most hearings are the situation when the employer has fired the claimant, and then I'd say that's about 75% of the hearings that I do, although we do handle hearings where the claimant has quit, and there are other issues as well, like availability or suitable work or inability to work, late filing, and we've even handled fraud cases successfully and helped people get their penalties taken away and had a good result for them. But in most cases, the first question the claimant will be asked is, did you work for this employer? What was your first day of work? What was your last day of work? What was the date you were actually separated? What was your position? And depending on the case, you'll go through the terms and conditions of employment, you know, the full-time, part-time, hours per week, regular schedule, rate of pay. Then the threshold question that has to be answered by both sides is, was the claimant separated because they were terminated or because they were resigning from their position? Now, if it is a resignation, that puts the burden to prove that you had a good reason to resign on the claimant. If, however, the employer terminated the claimant, then they have the responsibility to prove that they had a good reason to terminate. Now, the burden of proof means that whoever has that burden of proof, if they do not meet that threshold burden of tipping the scales in their favor, as far as by the preponderance of the evidence, then they haven't met that burden of proof, and the other side wins. Now, if I put that in practical terms, if the employer says that they fired the claimant for doing something wrong, and the claimant says that they didn't do anything wrong, if the judge sees that the employer's evidence that the claimant did do something wrong is equal to the claimant's evidence that he didn't do something wrong, then the employer is going to lose because they have the burden to carry that burden of proof. They have to tip the scales in their favor. If, however, the claimant if, however, the claimant resigned, he has the burden to tip the scales in his favor, showing the judge that the reason why he resigned is more likely than not that it was a good reason. And if the claimant fails to tip the scales in favor of him or herself, the judge will find that the claimant has not met their burden of proof. So it is important to decide and to establish for the judge, was it the employer's choice or the claimant's choice? In general, it's easier for a claimant to get unemployment if he was in fact fired, and it's harder for a claimant to get unemployment if the claimant in fact resigned. I hope that helps. If you have any questions, or if you have another type of issue that you need to consult with, feel free to contact me, and like I said, we can do that consultation either by phone or in the office, as I discussed earlier. Thank you.